And I just saw the confirmation. Meeting record in progress. Okay, so we should be ready to begin then. Good afternoon, everybody. And we are here for the continued hearing of case numbers 20, 2055, 62, 2066, 2067, 2068, 2069, 2070, 2071, 2072, 2073, 2135, and 2136. My name is Deborah Gailey. I'm with the City of Brentwood, and I will be the hearing officer. And for structure of the hearing, we will briefly hear from the code enforcement officers, and then we will hear from the appellant. Then each party will have an opportunity to provide any other additional information. And I will take all of this information and provide a written decision within 30 days. At this point, can we just for the record identify all parties? So if we want to start with our code enforcement officers.
Okay, I'll start. My name is Linda Shale. I am the code enforcement officer for the two cases 20-2135 and 20-2136.
This is Roberta Portillo-Beneman. I go by Robbie. I will be the officer for the remaining cases, and I would like to request just to have the most clarity possible, if we could, Ms. Gailey, have Linda Shale give her testimony on her two cases, which are for landscaping relations, and then perhaps we could move on to the, that way she wouldn't have to be on the call for the entire time.
Okay, that's fine. Can you confirm that I have included all of the case numbers?
There should be a total of 12 cases. 2 the sale, 10 would be fine. That would we have 12?
Correct, yes. Okay. Thank you. And from the appellant, would you like to introduce yourselves?
Sure, we have Mr. Brudico is here, Roberto Brudico. And then I'm as counsel. My name is Chuck Krolikowski. And I have a procedural and jurisdictional issue before we hear any testimony today regarding the hearing officer's ability to conduct a hearing as a city employee.
Okay, then let's go ahead and start with that.
Sure. A code enforcement hearing requires an impartial hearing officer, someone who lacks bias. And it's our position that having a city employee who is paid by the city, who likely knows the code enforcement people personally, is a biased hearing officer, and this would be a biased tribunal in that it's a city official and not a third party who's conducting this hearing. And in that regard, I want to ask the hearing officer questions to establish her bias in order to set aside any decision later with respect to any decisions made by the hearing officer in this matter. So are you willing to answer questions regarding whether or not you have the independence necessary to conduct a fair and impartial hearing?
Yes, that's fine.
Great. Okay. So how long, so this is, for the record, this is, my name is Chuck Krolikowski, and I'm asking the hearing officer, Ms. Gailey, questions. How long have you worked for the city of Brentwood?
24 years.
Okay, and they pay you, correct?
Yes.
And how much do they pay you each year?
I don't know that off the top of my head. I would have to look up the pay scale.
Oh, well, do they pay you more than $100,000 a year?
Yes.
Okay, and are you getting paid anything additional to conduct this hearing?
No.
Oh, so then you're getting paid by the city as an employee to conduct this hearing?
Yes.
Okay.
I have been Pursuant to Brentwood Municipal Code, Section 1.12.010, it says hearing officers may be designated by the city manager,
Yes.
must be an impartial person such as a city employee from a department which has no involvement in the matter being considered. And so I am one of the hearing officers that has been designated by the city manager.
Okay. Well, I have a lot more questions. So
Okay.
do you know Robbie, the code enforcement officer?
I do.
How long have you known her?
I couldn't say off the top of my head, probably since she started at the city, and I don't recall when that is.
Was it more than 10 years, you think?
Might be approximately 10 years. Like I said, I don't recall exactly.
Have you done anything with her socially, ever?
Not that I can recall.
You've never been to any event where she's been at? Cocktail event, dinner, city meeting, anything like that?
City meetings, yes, like council meetings.
And do you have an opinion as to whether she's trustworthy or not?
I guess that would depend upon how you define trustworthy.
Well, do you think she's a trustworthy person?
Yes.
Okay, so you already have a preconceived notion before she's presented any evidence today that she's trustworthy. Okay.
I don't believe she's untrustworthy.
Exactly. So Robbie, do you think she's a liar?
No.
So you already have preconceived notions as to Robbie's trustworthiness in this matter. Same questions with respect to Linda. How long have you known Linda for?
A few years. I believe Linda's been at the city a couple of years.
And have you ever done anything socially with her?
No, I have not.
Okay. So do you believe she is a trustworthy person?
I don't believe she's untrustworthy.
Do you think she's a liar?
No, I do not.
Okay. So going back to my first few questions before, how much approximately do you make as a city employee? Let's say for 2019.
Like I said, I don't know off the top of my head. I would have to look at the pay scale.
You literally don't know how much money you're paid each year as an employee?
No, I don't. Not off the top of my head.
Okay. Well, in 2020, is your salary expected to be over $100,000?
Yes.
Is it expected to be over $200,000?
No.
And what is your actual position at the city?
I am a senior analyst in the Public Works Engineering Division.
And do you know a person by the name of Casey McCann?
I do.
And who is Casey McCann?
He is our former Community Development Director.
And in terms of the pecking order of the city, what does the Community Development Director, what kind of position is that?
I'm sorry, can you repeat that? You were breaking up a little bit.
Yeah, is that like a supervisory position, the Community Development Director?
It's supervisory. It's also management.
And have you spoken with him at all regarding these matters?
No, I have not.
Now, do you know whether the city's produced all the documents I asked for in my public records request?
I do not. That would be for the city clerk.
Okay. Well, I'd like to share a document with you. If I can you see the document?
Yes.
This was a letter I sent on December 17th, 2020 to the city of Brentwood asking for many documents, many of which related to this code enforcement matter. Have you ever seen this letter before?
I don't believe so.
Okay. And do you know if the city produced all of its responsive documents within 10 days as required by the Public Records Act request?
I do not know. That would be for the city clerk's office.
Okay, well, I'm going to reference this and attach this as an exhibit to the hearing today. And I'm going to raise an additional objection that the city is willfully refusing to produce documents for purposes of proceeding with this hearing. So I'm going to raise that objection. I've got a whole list of questions for you. Okay. Now, do you expect to continue to work for the city of Brentwood?
Yes,
And do you expect to continue to receive money from the city of Brentwood?
yes,
By the way, did you receive any? So, are you working today as a hearing officer or as a city employee?
both. As an employee, I've been designated as a hearing officer, so it's one of my tasks.
Okay. And so, and you know the two witnesses that are going to be presented by the city today. I think it's Robbie and Linda.
Yes.
And how many other code enforcement appeals have you handled for the city of Brentwood?
I would say approximately 20 to 25.
And how many times have you cited for the property owner in any of those prior code enforcement hearings?
I would probably say 50% of the time. I don't know off the top of my head. That is an estimate.
Okay, so if I ask for all the public records of all your decisions, I will find out that 50% of the time you've ruled for property owners.
That's an estimate. And yes, the city clerk has copies of all of those decisions over the years.
And have you had any communications with any members of the public regarding this matter?
No, I have not.
Have you had any emails between any of the code enforcement officers in this matter?
No, I have not. Everything goes through the city clerk.
What do you mean everything goes through the city clerk? You send something to the city clerk and they send it to them, or?
Oh, no, I meant copies of the citations, copies of communications regarding the citations. They are all forwarded to me through the city clerk. I do not have any direct contact regarding the case with the code enforcement officers.
Okay, so you've never had any emails with Robbie or Linda about any of the citations in this matter?
Correct.
Okay, what about texts? Any texts with them?
No.
Have you had any phone calls with them?
No, I have not.
Have you had any discussions with Robbie or Linda about today's hearing
No, I
prior
have
to
not.
today?
No, I have not.
Do you interpret the city's municipal code? Is that part of your job?
Yes. We'll put it this way. I apply the city's municipal code.
And have you read the municipal code sections with respect to this matter?
Yes.
Have you received any advice from anyone regarding the code sections you referred to earlier about the city manager appointing you to be a hearing officer?
Advice, no, but I did speak to outside legal counsel about employees being appointed as hearing managers, and she just referred me to that section.
Oh, so if the code section says you could be a hearing officer, is that good enough for you?
The municipal code allows that, yes.
Okay, so
The municipal code allows the city manager to designate hearing officers, and one of those that they may designate may be a city employee.
okay, so if the municipal code allowed discriminating against people because of their race, religion, national origin, then that would be acceptable too, correct?
I think that's an irrelevant question here.
Okay, well, it is going to be a relevant question. So the fact that you work for the city, the fact that you know the witnesses, the fact that you already made a preconceived determination as to their ability to testify truthfully and not lie, I believe renders you an unbiased or a biased hearing officer. And I'm objecting to your ability to oversee the hearing on this. And I'm making that objection right now. And I'm requesting that you recuse yourself and that we get a hearing officer who is not a city employee, who does not have a preconceived notion regarding the ability of witnesses to testify truthfully and be truthful. And the city's municipal code, just because the city writes the municipal code X doesn't mean it's lawful. So I would object to the city's municipal code with respect to basically consenting to or allowing for the appointment of hearing officers that may be biased with respect to conducting a hearing. So, going to raise that objection. And also, with respect to the public records request, we asked for documents which should have been produced in advance of this hearing, and the city has willfully refused to produce the documents in response to a Public Records Act request. Therefore, we are prejudiced in our ability to defend against this matter, including the issue of your bias, because many of the documents we asked for included emails and texts and any other communications between city staff and departments.
Okay, I hear all of your objections. If you allow me just a couple of minutes, I am going to make a quick reference and I will be back with you.
Okay.
If you allow me a couple minutes.
Sure.
Thank you all for your patience. We're all ready, if we're all ready to continue. So, as I mentioned before, as set out in our code, appellants request a hearing, and when a hearing is requested, the city manager designates the hearing officer. And I have been the designated hearing officer. So we are going to continue with the hearing, and I will be the officer coming to a decision. So,
All right. Then I'm going to renew my objection for the record. And again, I'm making these objections for the record that the hearing officer is biased, that just because the city decides they're going to appoint their own people as hearing officers doesn't make it legal or right, and that the city has willfully failed to produce responsive documents to us, which is impacting our ability to present all of the evidence, including any evidence of bias on behalf of the hearing officer with respect to this proceeding.
okay, so noted. With that, we will start with Officer Shale and a brief summary of the two cases.
Okay. I was assigned a concern that overlapped two parcels on September 2nd of 2020. Since we assign our cases typically based by parcel, it was the same general concern, again, across two parcels. So I'm going to talk about them separately, if you don't mind, just because there is a little bit of difference between the two. So the first one we're going to talk about is case 2021-35. Again, September 2nd, 2020, we received a report of overgrown vegetation that was blocking the public right-of-way, specifically sidewalks, in multiple locations on the parcel 007-100-078. This has been a concern for this parcel in the past, so we went to a inspection and then a 72-hour notice that was issued on September 2nd. At that point in time, there were 4 locations on the parcels that had obstructions of the sidewalk. On September 8th, I conducted a follow-up inspection, and 3 locations on the parcel still had obstructions of the sidewalk. So we issued our first citation for that parcel. Another inspection was conducted on September 15th. The 3 locations still had obstructions of the sidewalks, so another citation was issued on September 15th, 2020. A follow-up inspection was conducted on September 22nd. Again, the 3 locations on the parcel had obstructions of the sidewalk, so a 3rd citation was issued. This occurred again on September 29th, with citations being issued, and again, inspections and citations occurred on October 6th. On October 13th, inspections were conducted. The 3 locations on the same parcel still had concerns with obstructions of the right-of-way, but when the inspections and so citations were issued, when inspections were conducted on October 22nd, at that time, all the vegetation had been cleared and the sidewalks were, the right-of-way was cleared, so we closed this case out. Following the same timeline, but on a separate parcel, we started case 20-2136. This is for parcel 007-100-129. This is again the same report that was originally called in on September 2nd. So the inspections follow pretty much the same timeline. On September 2nd, the concern was reported because this parcel had already had past concerns and notices sent out. We did the inspection on that day, and we located 3 locations on this parcel where there was concerns with overgrown vegetation, again blocking the sidewalk, and landscaping concerns. We mailed out that and emailed out that 72-hour notice. On September 8th, we did a follow-up inspection, and 2 of the locations still had concerns, so a citation was issued. On September 15th, we did a follow-up inspection. The same 2 locations still had concerns, so a second citation was issued. On September 22nd, inspections were conducted. 2 locations still showed concerns, and another citation was issued. This was citation number 3. On September 29th, an inspection was conducted. The 2 same locations showed concerns, so a 4th citation was issued. On September 6th, an inspection was conducted. 2 locations still showed concerns, so the 5th citation was issued. On September 13th, inspections were conducted, and at this time, 3 locations on the parcel were now showing concerns, so the next citation was issued. That again was on October 13th. On October 22nd, inspections were conducted, and all the vegetation had been trimmed back. All the tree clearances requirements were then met, so this case was closed.
Can you confirm how many total citations were issued for each case?
Yes. 1, 2, 3, 4, 5, 6. For 21, for 20-2136, 6 citations were issued. And for 20-2135, 6 citations were issued.
And both cases have been cleared, you
Both
said.
were cleared, correct.
Okay, thank you.
Okay, I have questions.
Sure.
Okay. I'm sorry, Linda, what is your last name?
Shale, S-H-A-L-E.
Okay. For the hearing, do you mind if I call you Linda or Michelle with any preference?
No preference.
Okay. All right. Linda, let's get informal. How long have you known the hearing officer?
Through name, probably for about 18 months to 2 years.
And you've never been to a social event with her ever?
No, I have not.
And how many employees actually work at the city of Brentwood? How many city employees are there?
I'm afraid I would not be able to answer that question.
Okay. Well, is there a city office where all the city employees kind of work?
There is City Hall.
Okay. And where is your office located?
In City Hall, bottom floor, first floor.
Okay. And what about the hearing officer? Do you know where her office is located?
I do not.
Is it in City Hall as well?
I don't know.
No. So citations were first started to issue on, looks like September 2nd. Is that about right? Or is that when the complaint was brought in?
I'm sorry, could you repeat that? You were breaking.
Sure. Were the first citations issued on September 2nd, or was that when the complaint was rendered?
Again, you're breaking up, but I think you're asking, was the first citation issued on September 2nd? And no, it was not. That's when the concern was reported.
Okay. And when were the first citations issued?
The first citations were issued on September 8th.
Okay. And then on October 22nd, it was confirmed that the weed abatement issues had been remedied.
They weren't weed abatement, they were vegetation and tree growth. And yes, they were confirmed on October 22nd that they had all been abated.
So about 45 days they had been resolved, approximately?
Yep.
Okay. Now, during the citation barrage between September 8th to about September 22nd, were there any communications with the property owner about their ability to comply with them due to the COVID restrictions?
There were none directly with the property owner, but there were with Roberto, the property manager, so the representation for the property owner. And none of those, any communication did not include restrictions based on COVID.
Oh, did Mr. Brutico ever advise you that it might be difficult for him to get people up there to do certain work because of the COVID restrictions?
I can't recall that. I don't know if he ever sent an email that included that verbiage, but I don't believe so.
Okay. And it's the city's custom during the COVID restrictions to continue to cite people week after week, even though they may not have the ability to comply?
That's a decision that's made above me from the community development director.
Oh, yeah. Speaking of the community development director, I believe that person, his name is at the time, was that a person by the name of Casey?
No, I believe Casey had already retired by September 2nd.
Okay. And who was the community development director after Casey?
Terrence Grindle.
Did you consult with him regarding the continuing issuance of citations during the COVID pandemic?
Following chain of commands, my communications were with my supervisor,
And who was that?
Robbie Portillo-Beneman.
Oh, okay. And how long have you worked for the city?
Just over 3 years.
Okay. And what experience in code enforcement did you have before you came to the city of Brentwood?
I worked for the code enforcement department for the city of Hayward.
And what remains of the citations with respect to the vegetation removal?
I'm sorry, you're going to need to hold still while you repeat that for me.
With respect to the vegetation removal, are there currently any outstanding issues with respect to that?
There are no open concerns at this time.
Okay.
What about?
Go ahead.
For these cases.
Okay. And what about, were there any fines levied with respect to these citations for the vegetation removal?
That's what the citation is.
Okay. And what's the amount of the fines?
The total that was issued. Let's see, hang on. I think I can tell you that. $2,300 for each case.
So every week you cite someone for vegetation and fine them $2,300? Is that what was happening?
No, that was the total. Our citation amounts, the first citation within a 12-month period is $100. If within 7 days it's not resolved, then it is $200. And then every citation after that, we typically do every 7 days, although we can do it every day if we chose to, is $500.
Okay. And resolving the issue in 45 days, is that considered a long period of time to resolve the issue or a short period of time in the code enforcement world?
A long period of time.
Oh, people don't have code enforcement open for 6 months, 8 months, 9 months?
Possibly. It varies.
Oh, have you ever seen a code enforcement action take a year to resolve? 2 years?
Yes.
Okay. And ultimately, is it your goal to obtain compliance with the citation?
Our ultimate goal is to obtain compliance without the citation.
And what pre-notices were provided to the property owner with respect to the vegetation before the citations were issued?
The 72-hour notice was posted, mailed, and emailed.
So you give someone 72 hours before you start citing them?
No, we give them 72 hours to show us progress.
And then if there's no progress, then you start citing them?
Correct.
Okay. And have you had any other code enforcement hearings where Ms. Gailey is the hearing officer?
I have not.
Well, What other hearing officers have you had code enforcement hearings with at the city of Brentwood?
I've only had a few, and I'm afraid I don't recall who what the hearing officers were. We'd have to look at the records with the city clerk.
But it wasn't Miss Gailey, though.
Correct.
Okay, so with respect to handling this, I'm going to be having Roberto provide testimony. But my thought was, why don't we have the city people go first, and then I have Roberto talk about everything? Is that appropriate, or do you want me to parse it out now with respect to the um, the vegetation removal and then the boarding up of the building?
Why don't we handle the two cases regarding the vegetation removal first, so that Ms. Shale may leave the call and continue on with other duties, and then we can listen to the other cases.
Okay.
Since she is the officer for only these two. So if Mr. Brudico would like to provide any more information.
Well, let me. Can you hold on for just 1 second? I'm gonna ask him a question.
Of course, no problem.
Sorry, can you hear me?
Yes.
Okay, my
Yes.
computer stopped for a second. Yes, I'm going to have Mr. Brudico answer a few questions regarding the vegetation removal. Mr. Brudico, did you have any resource issues with respect to dealing with any vegetation removal with respect to the property?
Yeah, yes, the Deer Ridge Golf Club has been closed. By the time this was these notices were being received, the Deer Ridge Golf Club had been closed for about a year, had no staff, no money, and we were in the middle of a COVID pandemic. As I think the folks on the phone call who are in Northern California know, Contra Costa County had a pretty severe stay-at-home order in place for much of 2020. And we had difficulty doing all sorts of things for this owner. It was difficult to find people. It was difficult to set them up, and when they were set up, there would be cancellations. So we had a lot of issues dealing with resources at this time.
And did you express any of those concerns, for example, in any of your appeal requests of the citations regarding the situation?
Well, I know it was discussed on the phone with, I believe, some folks involved with this, but in almost every single time I would forward the appeal letter to Margaret Wimberly, who's the city clerk, we would make a reference to disruption to services caused by COVID. I didn't elaborate as much as I'm doing with you now, because I knew she's not the right person to talk to. We had to just simply file our appeal, ask for a waiver of fee on behalf of the golf course, so we wouldn't have to post a fee in order to have this hearing. But virtually every single email to her where we forwarded the appeal, we referenced the disruption in services caused by COVID.
And once you were able to secure services of people to actually do the work during this pandemic time period, were you ultimately able to remove the vegetation that the city was claiming was in violation of their code?
Ultimately, yes. We never had an issue with whether the claim was a righteous claim. Our issue was, how do we get it done, and how do we come up with the money to pay for it? Because it would have been improper for us to contract with any labor or landscape company or somebody like that to get this work done without having an ability to make a payment. We couldn't ask people to do that. So we first had to figure out a way to get some money, and then we had to figure out a way to get somebody to do it, and then we had to schedule, and then there was the inevitable cancellations. But finally, things got done, and the matter was attended to.
Okay. And so with respect to the vegetation removal citations, are you requesting that the fines of, I think it's $4,600, $2,300 per case be waived as a result of your ability to finally get the resources to comply with the citations?
Exactly. I think we tried to comply and everything we could as promptly as we could, but the golf course was strapped and had issues. So to me, it's almost like it's unfair to expect that kind of turnaround when there's no staff, no employees. I'm down in Southern California myself. Very difficult to figure out how to get this stuff done. We did prevail sometimes on some people who we had worked with before, but it was not easy. So to me, you got to give folks time to work through problems. It's not a health safety issue. It wasn't like there was a public threat. It was an appearance issue, and we understand that. And we had to deal with it as best we could within the time frame we could.
All right, thank you.
Perfect. Well, thank you so much for taking this call. Do you have any other questions?
Okay. Any
So then-
other questions, comments, or input regarding those two cases?
No, our request for those two cases is that the ownership ultimately complied. They were able to it took them a little time to get the resources to do the vegetation removal, but they ultimately complied. And with respect to those two citations, they're requesting that the fines be reduced or eliminated because of the compliance.
do I go back now or am I done?
One moment, I'm taking notes.
Okay.
Okay. Unless you have any other additional information to add.
Just clarifications, and I'm happy with whatever decision is made because I'm happy we've reached compliance. But I would like to point out that we did let the property manager know from our first email, if you have any questions or comments, to please let us know. And we're always willing to work with people if they are explaining to us what delays might be occurring. But if we receive no communication, then we just move forward with the process. And while you would think that the overgrown vegetation is not a health and safety concern, in this instance it actually is, because it was blocking the right of way for some individuals completely to go by in these locations safely.
Okay. If there's no additional information or questions,
Well,
then,
actually, I have a question. I have a question there.
okay.
So I believe the vegetation that you're referring to was located near some sidewalks.
Overgrowing sidewalks, correct.
Okay. And so there was no possible way for anyone to get around those areas because of the vegetation?
For some individuals, that would be a risky behavior. Not all individuals have complete mobility where maneuvering around obstacles or walking along the edge of a curb is safe. So, correct.
Okay. And how many people made complaints to you about their inability to get around the sidewalk there?
In this instance, I'd have to go back and look. If you give me a minute, I think these both were based off of one reported concern. But let's check to see if any additional ones came in. Both of these individual cases were based on one concern being reported.
Okay. And this person's ability to get around to navigate the sidewalk, what was their issue?
I'm not sure I can reveal that confidentiality.
Oh, you're not going to let us know what this concern was about how they could navigate the sidewalk? I mean,
Simply, they could not navigate around the overgrown vegetation.
okay, and why not?
Again, I'm not sure if I can reveal that information.
Okay, so then, for the record, then you're refusing to provide information regarding this one complainant's ability to navigate around overgrown vegetation.
We make very strong efforts in keeping our reporting parties' information confidential. So I am not comfortable revealing any information I know about the reporting party, including their ability to move around the vegetation.
Okay, and then who else complained other than this one reporting party? I think there was nobody else, right?
In this instance, at this time, it was the one reporting party.
And does this reporting party regularly sue the city of Brentwood with respect to, let's say, ADA compliance issues?
No.
Okay. I have nothing further.
Hey, Charles, can I just add something? Because
Sure.
I think the code enforcement officer, I want to say it was Linda Shale, suggested that if we make the city aware that the compliance efforts are underway, then they do work with us and don't, to use your words, give us a barrage of citations that we're not able to immediately address. But I do want to point out, it maybe never made its way to Linda Shale or even to Robbie, but the golf course had in discussions with the city for a long, long time about those parkways where this overgrown vegetation issue occurred. It was made known to the city that when the golf course went out of business, two things happened. It didn't have the ability to maintain them or even to water them. And that's for a couple reasons that maybe needs to be brought up here. The way the city of Brentwood entitled this golf course project, and the current ownership group didn't own it, wasn't part of the entitlement process, and just took it over when it was in financial extremis. But the way the city entitled it and planned it, the golf course would have responsibility to maintain these strips of land that directly abutted it. And I guess the homeowners in other cases would have it where it directly abutted the homeowners. So what happened with the golf course is all of its irrigation system failed in September of 2019, and its ability to maintain these strips was compromised, and you had an insolvent business. Discussions were had with the city to simply give this land to the city. And a lot of discussions have been had there where the city is interested in acquiring all these park strips that the golf course doesn't have the ability to maintain. It's just an impossibility. So the golf course had offered to deed those strips of land or provide a license or an easement or whatever the city wants to give it to the city to include in a landscape and maintenance district for this particular residential development. Those discussions progressed. I understand there's been an advisory. Finally, the city, I think, worked up the cost to do that. I believe they put out an advisory vote to the affected residents. My understanding is they needed 50% or more of the residents to say, yeah, it's a good idea. I think I'm of the opinion that they have obtained more than 50% and are proceeding with the formal vote required to take the park strips over, these strips of land over, and put them into a landscape maintenance district. And that's underway as we speak. The hearing officer and the others can verify that with the city. I think Terrence Grindle is probably the most familiar with it, and he's the man who was referenced earlier in the call is directing code enforcement here. So I bring all this up to say all the problems that the golf course had in maintaining it was disclosed probably more than a year ago. Offers were made within the golf course power of how it could be accomplished by ceding over the maintenance and the ownership or the access to the city, and a discussion had about how that might happen in the form of putting it into the landscape maintenance district for this particular homeowners association, so or residential development. So I just want to make sure, maybe Ms. Shale didn't know, but this was in the air for the entire time and many months prior to the time these citations were issued.
Thank you.
Okay, so that should conclude our information for citations 2021-35 and 2021-36. So Code Enforcement Officer Shale, if you would like to continue with us, up to you.
If you don't see, I will sign off. I've got quite a bit of work to do.
Okay.
Thank you.
Thank you.
Thank you.
Okay, moving on. We will hear from the enforcement officer for the remaining cases, which I believe we have already listed. So if you'd like to begin, Robbie?
So I would like to, if everyone is in agreement here, I would like to refer to 9 of the 10 cases in bulk. My explanation for that is all of the cases, with the exception of 20-2055, which is for the former clubhouse, the other 9 cases pertain to the K-rail barriers. And we have the same inspection dates and citation dates, etc., for all 9 of those cases. There were a total of 9 cases with 8 citations being issued for each of those. So that's a total of 72 citations. So if you are on board with that idea, Ms. Gailey, I will go ahead and give testimony for case 20-2072. However, referencing those citation dates and the notice dates, they carry over to the other 8 cases pertaining to K-rail barriers, if that makes sense. Otherwise, I think we're just going to get knee deep in details. Does that make sense?
I agree, yes.
Okay. All right. So with I have a appeal hearing summary of action if you'd like to follow along on that. And then as part of the first first set of documents that was provided, there was a map of the various locations of the K-rails, and I believe that's on pages 366 through 370. And that will outline on the map the 15 various locations where K-rail barriers were placed. And then the municipal code sections that pertain are included on pages 371 through 373 on that first set of documents. The municipal code section that pertains here is Brentwood Municipal Code section 8.00.030, unlawful activities K like king. This began with an email that was sent to the property manager, Mr. Roberto Brudico, on August the 14th, advising him of the Brentwood Municipal Code violations for the orange K-rail barriers at those 15 locations, with a request for those violations to be corrected. I then followed up on August the 17th, attempted a phone call and left a voicemail message and an attempt to discuss the violations with him. And then I followed up with an email advising that I had again left that voicemail message, advised a 72-hour notice to abate would be issued the following day, August 18th. I emphasized the goal was voluntary compliance, and I did receive a response on August the 17th, indicating that the golf course had concerns respecting the ordinance, that it needed to reconcile before taking any action. So I went ahead and proceeded with the enforcement action on August the 18th. I conducted an inspection, again, at all 15 locations. This includes 9 cases here. There were K-rail barriers, at those 15 locations. I issued a 72-hour notice to abate. The municipal code requires that we mail that and we post it at the property. Instead of posting it on 15 different K-rail barriers, I did post it at the 801 Foothill Drive address, which is the former Deer Ridge Golf Course clubhouse. All of the notices throughout these cases were posted at that location. And then above and beyond just mailing and posting it, I also emailed it to Mr. Roberto Brudico so that he would have the document immediately. Follow-up inspection was conducted on the 20th. Again, at all 15 locations, the K-rail barriers remained. Therefore, administrative citation number 1 was issued in all 9 cases. Again, mailing it, emailing it to the property manager, and also posting it, at that 801 Foothill Drive address. Subsequent to that, August 30th, another inspection was conducted. Again, all 15 K-rail barriers were still present. Issued a second citation for $200 on all of the cases, mailed it, posted it, and emailed it to the property manager. On September the 8th, I was advised by the city clerk's office that an appeal had been received for the second citation that was issued on August the 30th. On September the 11th, another inspection was conducted. Again, the K-rail barriers were all still present. Issued a third citation in all of the cases, which was for $500. Following protocol, mailed it, posted it, emailed it to the property manager. Subsequent inspection on September the 18th, again, all 15 K-rail barriers were present. Issued another citation, again, for $500. This is now the 4th citation for each case. Mailed it, posted it, emailed it to the property manager. I was notified on September the 24th that the city clerk had received an appeal for both the second and third citations that were issued, and then an administrative hearing would be scheduled. Subsequent inspection was conducted on September the 25th. Again, all 15 K-rail barriers were present. A 5th citation for $500 was issued on all 9 cases. mailed it, posted it, emailed it to the property manager. On October the 2nd, another inspection was conducted. Again, all 15 K-rail barriers still present. Issued citation number 6, again for $500. Mailed it, posted it, and emailed it to the property manager. Received notification that same day from the city clerk's office that they had that the appellant had appealed the citation issued on September 25th, which would have been citation number 5. Moving on, another inspection was conducted on October the 9th. 15 K-rail barriers were still present. Citation number 7 was issued for $500 on all 9 cases. Mailed it, posted it, emailed it to the property manager. I received notification from the city clerk's office on, October the 15th that an appeal was received for the citation issued on. Next was conducted on October the 22nd. All 15 K-rail barriers were still present. Issued the 8th citation for $500, mailed it, posted it, and emailed it to the property manager. I then conducted an inspection the following day on October the 23rd because I was notified that some of the K-rail barriers had been removed. I did conduct an inspection. 14 of the 15 K-rail barriers were removed. At that time, I believe that maybe so I did email Mr. Brudical, manager, just to clarify, was that an oversight? Had they intended to remove that 15th K-rail barrier, which was located off of Torrey Pines Drive? He did, in fact, indicate that that one was inadvertently left and that they would be removing that. On October the 27th, that remaining K-rail barrier off of Torrey Pines Drive was, in fact, removed. So we got compliance on all of the K-rail barriers by October the 27th. I received notification from the city clerk's office. An appeal was received for the citations issued on October the 22nd, which was the 8th citation. And at that point, we were waiting for an administrative hearing to be scheduled, which, as we all know, was scheduled for November 10th. And subsequently continued until today, January the 5th. So having said that, that is all of the testimony relating to the 15 K-rail barriers encompassing those 9 cases. I did provide copies of the relevant Brentwood Municipal Code section. There are photos included on all of the notices and citations that were issued. And the aerial map outlines all of the locations of the K-rail barriers. So with that, that'll conclude my testimony for those 9 cases.
Brief question. So just to clarify, 9 cases relating to K-rail placement, 8 citations each. And can you tell me the dollar amount of the citations for each of the cases? I assume they are the same amount.
That will if you just a moment. I don't want to give you the wrong amount. Okay, that would be $3,300 times 9.
Thank you. Okay.
Okay, so should I deal with the K-rail case first?
Please, go ahead.
Sure. So Robbie, is it okay if I call you Robbie?
Sure.
Okay. So how long have you known the hearing officer?
I don't know. I've worked for the city for a number of years. I'm sorry, I can't answer that question.
And how many years have you worked for the city of Brentwood?
16.
Okay. And do you know if Ms. Daly also worked at City Hall?
I don't know where her office is. I would presume it's at City Hall, but I don't know.
Have you ever had any email or text communications with her ever?
No text, and I'm not certain about emails.
Well, did you look for any emails that you may have had with her?
I've had no emails in regards to this action, in regards to the appeal hearing for Deer Ridge, but for other city matters, perhaps. I've worked for the city 16 years, so it's quite likely.
Okay, so you were issuing multiple citations for the same K-rail? Is that right?
Well, actually, there were testimony we by K-rails actually located on 9 separate parcels owned by Deer Ridge, so that's why there's 9 cases. So the citations were issued per parcel, if that answers your question.
And so you couldn't have issued one citation saying, I've got 15 different K-rails on these properties, please remedy that?
Our cases are per parcel, so our citations and our enforcement actions would be per parcel.
Okay, is that a legal requirement or is that just a rule that you guys follow?
That's a policy we follow.
Okay, is that a written policy?
That is not a written policy.
Okay, so is there a written document which says that you are required to issue different citations for the same type of violation if they're on different parcels?
I am not aware of such a document. Our Brentwood Municipal Code specifies that each violation, each day would be a new and separate violation. So technically speaking, our municipal code gives us the ability to issue daily citations. However, our policy has generally been that we issue them on a weekly basis, which is usually every 7 days.
Okay, is there some type of like bonus or additional compensation you're paid based upon the number of citations you issue or fines you try to collect on each year?
Absolutely not. Our goal of our program is voluntary compliance. And I would say that the vast majority of our cases, we do obtain voluntary compliance. We don't have to issue very many citations.
Okay. And so the 9 parcels, are any of those zoned for residential development, those 9 parcels?
The 9 parcels are open space golf course.
Okay, are they zoned for residential development?
My understanding is that they are zoned for open space golf course.
Okay, and do they adjoin property that's zoned for residential? All 9 parcels?
They are adjacent to residential parcels, yes.
I didn't say adjacent, I said adjoining.
Well, mine would be adjacent or contiguous. If you'd like to use adjoin, that's certainly your prerogative, sir.
Okay, so are there any streets in between any of the parcels and any of this allegedly adjacent residential development?
I believe all of the parcels are adjacent to streets. Purposes go throughout the Deer Ridge area.
I'm sorry, you kind of went out there. Could I get that again?
There are streets that circulate throughout the Deer Ridge neighborhood, but all of those parcels are adjacent to residential properties, to residential homes.
Okay, and what does adjacent mean to you?
Next to.
Okay, which means there's absolutely nothing in between. No street, no sidewalk, no other intervening parcels?
There's quite a few parcels up in Deer Ridge. I think maybe it would be best if we referred to the aerial map. What specifically are you asking? Because I'm not sure I understand the point you're trying to make.
I'm just asking you, are all of the 9 parcels, do they all adjoin property that's used for residential purposes?
I believe that would be, and there are some golf cart paths, some paved pathways that go through the parcels. but at some point they are adjacent to areas more closely to residential homes than others.
Okay. So you you keep wanting to use the word adjacent. Um, why do you want to use the word adjacent as opposed to adjoin?
The same question, sir. Why would you want to use the word adjoin rather than adjacent? What is the point that we're trying to get at here? Am I not answering your question thoroughly enough? I'm not sure what the point is you're trying to make.
No, I'll get there. I'll get there. Okay, so this rule, 8.00.030 subdivision K, when did that rule come into effect about K rails?
The ordinance was modified at a council. We had 2 council meetings. 23rd, 2020 was the first agendized meeting, and that was the first reading of the modification to the municipal code, followed by the second reading on July 14th. The 8.00.030 was already in effect. However, there were modifications made to the ordinance, specifically relating to temporary barriers and vacant buildings and so forth.
So, and when did that ordinance come into effect? Isn't it 30 days after the second reading?
That's correct. 30 days after the second reading. So that would have been August 13th of 2020.
Oh, and the next day you sent the notice on August 14th about the K-rail, correct?
No, sir. I actually sent an email on August the 14th. The 72-hour notice wasn't sent until August the 18th.
Okay, and why did the city change the rule to include K-rail as of August 13th, 2020?
That's a good question. That would be probably a question for a retired city employee. Mr. Casey is the staff member that took the staff report to council. And as I think it was mentioned in the previous testimony by Ms. Shale, he retired in July. I believe it was mid-July. So he's the one that took that matter to council. Generally speaking, ordinance modifications are requested by city council, and city staff is directed to modify ordinances or enact new ordinances, and then it's brought forward to city council.
Is it your understanding that this ordinance was passed directly aimed at the subject properties because they had K-rail on them already?
I can't specifically give you that answer. I'm not sure. I didn't work on the ordinance modifications. My job is to enforce the municipal code as written. I didn't write the modification, so I wouldn't be able to answer that question.
Did the K-rail exist on the properties prior to August 13th, 2020?
Yes.
Okay. And prior to August 30th, 2020, there was no prohibition on the use of K-rails, correct?
The municipal code is not specific to K-rails.
Okay, so there was no municipal code section which said K-rail, the use of K-rail was impermissible as a barrier prior to August 13th, 2020.
That is correct, and there wasn't a municipal code that specified they were, they could be legally used in that same thought, temporary fencing, etc. There was no specific mention of that. They were not included as part of the original approval for the Deer Ridge Golf Course.
Oh, let's talk about that. The Deer Ridge Golf Course, did that Deer Ridge Golf Course require a CUP to operate as a golf course?
It's zoned for open space golf course use. I didn't prepare research for that today, so I would have to go back and look and see if there is a CUP for Deer Ridge, for the former Deer Ridge Golf Course.
So as you sit here, you don't know if there's a CUP for the Deer Ridge Golf Course?
I am not aware of that.
Do you know whether the golf course club facilities are an ancillary use to the golf course facility itself.
Or excuse me, the former clubhouse is on a separate parcel, 801 Foothill Drive. There's a separate permit for that structure.
Now, so have you ever heard of the term legal nonconforming use before, or something that's grandfathered in?
I have, yes.
Okay. So prior to August 13th, 2020, there was no prohibition on the use of K-rail as a barrier for property, correct?
Specifically that K-rails were not permissible.
And did you receive a complaint from anybody regarding the K-rails on the property?
Numerous complaints, yes.
And when did those complaints start coming in? Before or after the city changed the law in August of 2020?
I believe the community was upset about the presence of the K-rails prior to August 14th, 2020. However, there were no complaints actually being logged because there was no code violation at that time.
Oh, only until after the city kowtowed to the residents and changed the law did the citations start to be issued? I'm sorry, that's an argumentative question. Let me ask you a different question. Now, do you understand that the golf course had to use barriers to protect its own property?
That's the golf course's opinion. Whether they were effective or not, that would be a whole nother discussion.
Okay, does the city have a police?
Many property owners feel the need to secure their property. Most property owners will do that installing a fence or a wall, something along those lines, an actual barrier. I'm not aware of any other property owners within Brentwood that have utilized a K-rail style barrier to have for their property.
Oh, so if there was no other K-rail barriers, then this law specifically targeted the subject property when it determined that it should bar the use of K-rail, correct?
That's not what I said, sir. What I said is I'm not aware of any other property owner attempting to utilize K-rail barriers to secure their properties. On occasion, there are K-rail barriers that are used for construction sites, etc., on a temporary basis, but not as a means to secure their property. I believe your question was I aware that Deer Ridge was trying to secure their property? Yes, I'm aware that they were trying to secure their property. However, most property owners will secure their property by utilizing fencing or walls. That was my answer.
Okay, you understand a golf course, it would be quite expensive to fence or use walls for an entire golf course.
We actually have another golf course in Brentwood that does precisely that.
Okay, so and how much would it cost to fence the entire golf course versus put up some K-rails? You know the difference between the two? Okay. Now, does the city of Brentwood, do they have their own police department or do they use like the sheriff's department?
We have our own Brentwood Police Department, city staff, yes.
Okay, so what happens in a situation where the police allows someone to drive their vehicles all over the golf course and do graffiti, and then they cite the owner for things that the police should have handled? Do you ever come up in those situations where something should have been handled by the police and then it's not, and then the owner gets cited for it?
So I can't use specific policy-related answers related to the police department because I'm not a police department employee. I can give you a general answer dumping or graffiti on any property within the city limits of Brentwood, that's considered vandalism. And the private property owner is responsible for correcting the violations and cleaning up whatever illegal dumping or graffiti, whatever type of vandalizing of their property has taken place. Unfortunately, yes, they are a victim, but as the property owner, they are responsible for maintaining their property. So those matters are addressed accordingly. Trespassing issues are civil, and those go directly through our police department.
Okay. Now, what was the time period? You said I think you said by October 27th, all of the K rails had been removed, or at least 14 or 15 of the K rails had been removed.
All of them were removed by October 27th, yes.
Okay. And when was your first citation issued? Near the end of August?
Just a moment. The first citation was issued on August 20th.
So it looks like a little over 2 months for the K rail to be removed. Correct?
That sounds correct, yeah.
Okay. And did you ever ask Mr. Brutico if he had the resources or the wherewithal or the ability to have someone go out there and remove the K rail?
I never had a verbal conversation with Mr. Brutico. I believe all of the communication was via email. I would have to say that, this would be an assumption on my part that he had somebody go up to the various locations, the 15 locations, to drop them off or install them. So he should have been able to contact those same individuals and remove them. I believe they were rented K-rail barriers, if I'm not mistaken. So there was a company that could have been contacted to remove them.
When were they installed, the 15 K rails?
I cannot give you the exact date. I don't monitor that property, nor do I monitor any location in the city of Brentwood on a daily basis.
Okay. Well, was it before the COVID, or was it after COVID in March of 2020?
2020 has been a blur, as it's probably been for most of us. I honestly can't tell you if it was prior to mid-March or after mid-March. I don't have a recollection of that.
So okay, well, let's do this. Let me show you a document. I'm going to share. Okay, so actually, for the record, I've already shared the document request letter, and I'm asking that can be part of the permanent record. And I'm going to ask the hearing officer, what's the best way to get that to you? To email it to you? Can you print it out? Or how are we going to make that part of the record?
You should provide that to the city clerk. She keeps the official permanent record.
Okay. What I'll
And
do
she'll provide copies of all documents to me.
Okay, great. Okay, so what I'm sharing with you is an email, and it's from March 12th, 2020, which you would agree with me is before the March, I think, 16th or 18th COVID lockdown in the state. You recall that?
I do recall it. I believe it was around March 17th, yes. Mm-hmm.
Yes. And in this email from Casey McCann, who at the time was the Director of Community Development. Do you see that? Casey McCann?
I do.
Okay. And in the letter, he refers to K-rails. Remove all K-rails and replace them with bollards, chains, and warning, no trespassing signs. Do you see that?
Yes, sir, I do.
So would this help, not refresh your recollection, but confirm with you that K-rails had been put in place before March 12, 2020?
Based upon what you're showing me on your screen, I have no reason to doubt that that's a legitimate email. I don't have any knowledge of that email ever having been sent. My name isn't on it, so I've never seen such an email.
Okay, well, it's from Casey McCann to R. Brutico on March 12th, 2020. You've never seen this email?
I have never personally seen the email, sir, no.
Okay. Then, so prior to COVID, it appears that the golf course put up the K-rails. And then during the COVID, after the city decided to change the rules, you started to issue citations to the property related to the 15 K-rails.
That sounds accurate.
Okay. And uh, did you have any concern that it might be difficult for the ownership to get the resources together during the COVID outbreak, during the lockdown, during the pandemic, to get the resources together to remove the K-rails right away?
Not at the time the enforcement commenced. Again, the enforcement commenced mid-August. I think the greatest restrictions for the lockdown were from probably mid March through probably mid-May. And mid-May is when construction was able to resume. So construction was deemed essential. And I don't believe there would have been restrictions for a construction company to remove barriers, install barriers, barricades, etc. We had quite a lot of construction going on in Brentwood, as did, I'm sure, other cities.
So it didn't concern you at all that it might be difficult for the property ownership to remove the K-rails, within a few days or within a few weeks?
Mr. Brudicow did not indicate any arrangements within a few days or a few weeks. That information was never given to me.
Oh, in his appeal requests and all the different emails he sent, he never notified you that it might be difficult for him to get any of these things done, all these code citations?
In his emails, my recollection is that he spoke about the business being insolvent, the former Deer Ridge Golf Course was closed, but there was never any mention of him actually contacting anyone and making arrangements. He never gave a date to say date. That information was never provided to me, at least.
Okay, so when Mr. Brudico tells you that the club's insolvent and has money issues, rather than work with him to remove the K-rail, you just continue to issue citation week after week? In fact, 9 citations week after week?
The procedure or policy that we have in place is we notify an individual of a code violation. We attempt voluntary compliance. And if they don't comply, we have to resort to the administrative citation process, which is in fact what occurred here. If an individual gives us documentation that they are making taking the actual action to bring their property into compliance, and we can verify that, and we can work with them on a timeline. That didn't occur here. I was never given any written documentation by Mr. Brudicow that he had contacted anyone to make arrangements to have the K-rail barriers removed.
Well, you don't know that. I mean, you didn't even know about the email that Mr. Casey sent to Mr. Brudico in March of 2020, right?
What I said was, sir, that he never provided me written documentation that he had made arrangements to have the K-rail barriers removed. If he was working on that, he didn't provide that information to me.
Okay. He may have talked to somebody else, though, about it.
That's certainly possible, but I didn't have that type of communication with him.
Okay. Now, would Mr. McCann, would he be considered your supervisor when he was there at the city?
Mr. McCann was community development director. I report directly to the chief building official, and then through the org chart, it would then be the community development directors. Retired.
Okay. And so did you ever receive a formal complaint about the K-rails?
Many complaints, sir.
Okay, no, I mean, after August 13th, 2020, did you ever receive a formal complaint about the K-rail, which started your code enforcement proceedings?
Yes.
Okay. And how many complaints did you receive?
Numerous. There were multiple for each location. I don't have a number for you, but more than 10.
Okay. Okay, so can the property owner put up giant rocks where the K rails were, or big sand dunes, or dirt berms?
You bring up dirt because the property owner or property manager did just that. And moving that dirt does require a grading permit. And I believe there was a separate action that I was not involved in from our Public Works Engineering Division for piles of dirt that were placed in, I don't know if they were in all of the exact locations, but many of the same locations where the K-rail barriers had been.
And what's the quantity of dirt in any specific excavation area that requires a city permit?
I issue grading permits and I don't work in public works engineering, so I don't have that answer for you.
Okay, and how much, let's say in K-rail location number 3, wherever that is, how much dirt was moved in that area? How many cubic yards?
I would be speculating, you can't hold me to it. I would say there's probably at least 8 or 10 yards of dirt would be my best estimate.
Okay. And what's the city requirement for getting a permit to move dirt around?
That would certainly require a grading permit.
8 or 10 yards of dirt?
They were excavating dirt from other locations within the Deer Ridge development and moving that dirt to the various locations where the K-rail barriers were. And the information that I had heard, again, it was not my action. I was not involved with that specifically, but that a grading permit would have been required for that. And the Public Works engineering staff followed up on that. So you'd have to contact somebody within Public Works engineering for more details on that.
Got it. Okay.
One point that I would like to make, the question of the ability of Mr. Brudicow to remove the K-rail barriers. An interesting side note, there were some K-rail barriers at the Shadow Lakes location at the entrance to the clubhouse and driving range there. And I did send the very same notice to Mr. Brudicow and then also the acting, perhaps he's the site manager, Bill Hill, and those K-rail barriers were subsequently removed very promptly, in fact, and some bollards and chains were installed. So, I guess having said that, it would appear to me that if those were able to be moved from another location that Deer Ridge Golf owns, they should have been able to be removed from the 15 locations on the former Deer Ridge site.
Okay, and
Yeah, let me just interject something, Charles. I've been
Go
listening
ahead.
patiently, and I will do that again, but I'm going to interject something. The Deer Ridge Golf Club does not own the Shadow Lakes facility that is operated by Bill Hill. There is no commonality of ownership. Bill Hill has a business that was open. He has staff, he has employees, and he handled that on behalf of Shadow Lakes. So Shadow Lakes is a different business than Deer Ridge, and it's important to make that distinction and to keep that in mind.
Okay, thank you, Roberto. Okay, so didn't you determine that the K-rails were put in place before the laws changed, and therefore they should remain there, or they could remain there?
The direction that I was given was that we had a municipal code violation and community enrichment needed to enforce for those code violations. So therefore the cases were generated and the notices that I gave testimony on were sent to the property owner and the property manager.
Who gave you that direction?
That was direction from the then community development director, which would have been Casey McCann. And I would make another assumption that being that these ordinance modifications were taken to council, that those would have been reviewed by our legal department. And, you know, given the blessing by city council when they were approved on those two council meetings.
When did Mr. McCann give you the direction to start conducting code enforcement related to the K-rails?
Actually, I misspoke on that. Mr. McCann had retired mid-July, so the direction was given from the interim director. That would have been Terrence Grindall. I misspoke.
Okay. And how did he give you that direction? Verbally, in writing?
That was verbal direction, sir.
And when?
The verbal direction, I believe, was given on August the 13th. It would have been the day before I sent that email out.
Okay. Well, I have no further questions regarding the K-rail, but I do have some questions for Mr. Brudico. Can I proceed?
Yes, please.
Okay. Mr. Brudico, ultimately, you did comply with removing the K-rail. Do you recall that?
I do.
Okay. And did you have any issues with respect to, similar to the vegetation removal, any issues with respect to gathering the resources to get that done?
We did, and it was a more complicated problem than the landscaping issue.
And why is that?
Primarily because of this law changing after we had put these barriers in. The primary concern of the Deer Ridge Golf Club was to help protect persons and property from injury and help protect the property from trespass and vandalism. Ms. Portillo is correct that the barriers are not necessarily effective because they were just placed over the entry points to the property. It's a large property. It goes on for 185 acres, I think. There are a number of places where the cart paths abut streets. On advice of a council, when the golf course shut, it needed to take some measure for its own liability purposes to keep to make the public aware this was no longer a maintained area, to disinvite the public from coming onto it because they could be injured. And we did have a lot of public incursion, lots of trespass, vandalism. And it's not even necessarily the acts of vandalism that concerned us the most. It's when they trespass and commit vandalism, are they going to get injured on a property that's no longer maintained and no longer watched? So the barriers were put up on advice of council before this law changed, and that's why they were put up. Once the law changed, we had a concern because, and everybody who's on this call and everybody who lives in that town ought to be honest with themselves. This was a politically motivated change. If you read the ordinance carefully, there's very few properties probably that even applies to outside of the Deer Ridge Golf Club. But it is politics, and politics came to bear. However, even a politically motivated change, it has to be assessed in the context of public safety and liability and whether it's a valid law. It sort of gave the Deer Ridge Golf Club a bit of a Hobson's choice. Do we immediately comply with the law and risk liability for being negligent, for not adequately warning the public of a prospective danger? Or do we keep the barriers in place and incur the wrath of the city? I don't blame Robbie or the code enforcement officers. They aren't part of what happened at the higher levels in making these decisions to go after the golf course because surrounding residents weren't happy with the condition of the property. They didn't like looking at the color orange, I guess, something we didn't know for many months after the K-rails went up. But we needed time. We needed time to evaluate whether this was a lawful request or not. The very first thing I did after I got Ms. Portillo's first notice, I believe, was I sent her a letter. And I'm trying not to involve, as I said, the code enforcement people because there were discussions going on with the assistant, I think acting city manager at that time, and others. this is not an appropriate thing to try to go back and forth with on folks just doing their job out in the field. But I did write Ms. Portilla Vanneman a letter and said, look, I'm working with them, got your letter to remove them. We have concerns respecting the ordinance which need to be reconciled before taking any action, including liability and safety concerns. We are trying to engage Municipal Law Counsel to review and advise. We ask that the item be held in abeyance until that can be accomplished. This is a peculiar action by any measure that a law comes in and then seeks retroactive application, especially when there are liability issues involved and public safety issues involved. So, starting in August 17, when I contacted Ms. Robbie here, I started trying to find legal counsel for the golf course. We had a couple options up in Northern California, both of them washed out for different reasons. It took us a while to finally get to counsel who's on the phone with us today. And I don't know exactly how far, Charles, you want me to go with
Well,
with what I asked you to do, but you know, you got engaged and we made a decision that under the circumstances we would remove the K-rails. But that took time, and it's a reasonable amount of time given what was going on. So this is a very different problem than maintaining the landscape and getting somebody out there to cut the landscape.
Okay, so you did advise them that you were trying to figure out this new law, which you believe targeted your specific property based upon the ire of the neighborhood, correct?
Absolutely, but I didn't want to keep beating the drum on Robbie.
Yeah.
She really wasn't the villain here. I just wrote her one letter, but I copied that letter on every appeal and included it with every appeal to Margaret Wimberly, the city clerk.
Okay, so you were communicating with them that you're trying to figure this out. You ultimately made the decision to remove the K-rail approximately 2 months after receiving the first notice, correct?
Correct.
Okay. Now, did the barrier, the barriers I'm assuming were over areas where there were either cart paths or roads or things like that, like access points?
Exactly right. They were
Okay.
Cart paths where people can access the interior of the golf course from sidewalks or the other areas.
So were the K-rails being used to protect the property?
Both protect the property and to warn the public and protect the public.
Okay. And so, and prior to the law changing, you weren't aware of any prohibition on the use of K-rails to do that, correct?
There was no prohibition on it. In fact, even after the law changed, there's still no prohibition unless you're on a property that is situated like the Deer Ridge Golf Club. That's another concern we had is with the law itself. It seemed to be very thinly targeted or very thinly worded to be targeting the golf course.
Okay. Well, those are the questions I have with respect to the K-rails.
Let me add one thing, Charles,
Sure.
that came up in Robbie's comments as it relates to the dirt barrier. When the K-rails were removed, dirt barriers were put in their place because they are not illegal under the code, at least not that we could see. The reason they were put there were for the same reasons I've articulated already. There is a concern about warning the public, dissuading the public. Robbie's right. People can walk around rails. They can walk around dirt piles. But from a level of negligence, if we're sued because someone's injured or somebody's killed or something happens out there, we want it to be for the Deer Ridge Golf Club to be able to say they did what they could to warn people and dissuade people from accessing the site. So the dirt barriers went in. They were small. They were about 3 feet, I'm guessing, maybe a little, probably about 3 feet high, and they just simply crossed the cart path, the same place the K-rails did. They did not involve a grading permit. I think that's, probably a lot of rumors go on in Brentwood, it seems, as it relates to Deer Ridge, because our understanding was unless you move 50 cubic yards of dirt, you don't need it. But whether you do need it or whether you didn't need it is sort of irrelevant. We got a call, I want to say it was from Tim Ogden, the city manager. It could have been Terrence or could have been both, I cannot remember now, asking if we would please remove the barriers. They're creating a fuss, and the dirt barriers this time. And he indicated that, gee, there could be some other violations, even though they're not grading permit violations. They might be Clean Water Act and runoff issues. And he said we'd rather not go there. So we took those off too. At least we asked that they be removed. But you see, the issue we're grappling with is this issue of liability and public safety and whether this ordinance is a legitimate one or just a political persecution.
Got it. Okay. Thank you. Okay, are we going to move on to the building?
Unless there are any additional questions or information that wants to be provided regarding the K-Rail citations?
Well, I have an argument regarding the citations, but is that better left for the end, or do you want me to present my position on that now?
Why don't you go ahead and present your position on that now while the details are still fresh from the discussion?
Sure. So first couple items, again, similar to the vegetation, it did take my client some time to figure out this new law that came into effect. Obviously, he had to engage legal counsel to talk about what he should and shouldn't do. You had a new law which, appears to be targeting his property and or was brought about by political reasons. We have this issue of whether or not the use of K-Rail prior to the adoption was grandfathered in or some type of legal nonconforming use prior to the adoption of the new legislation. That's an issue, which this hearing officer will need to decide. But the other issue is the code itself, and this is why I was asking specifically about whether or not it was adjoining, because the code itself, which I'm going to do you have that? Can you see that or no? Maybe not. Let me try it again. Let me try sharing it again.
I can see it. Yes, it's just small. So I'm going to call it up in a larger version. You had 8.0.
Yes. So 8.00.030. Let me see if I can do it again here. Okay, well, it's you can't quite read it, but 8.00.030, subdivision K, item 2, says any K-rail or Jersey barrier, concrete or plastic, installed on property that is either zoned to allow residential uses or adjoins a property zoned to allow residential uses. And so Robbie admitted that our property is not zoned residential. She said it's zoned open space. And then I kept asking her about adjoining, and she kept using the word adjacent. And so the city would need to prove that all 9 parcels adjoin property that's zoned to allow residential uses. We need to prove that in order to meet this standard under the code. And adjoining, the question becomes, what does adjoining even mean? And so is it, if there's something in between, if there's a road or a right-of-way or an easement or any other type of intervening use or property type or easement or encumbrance or anything, whether or not the 9 K-rails are on, or the 15 K-rails are all on properties that are on properties that adjoin property zoned to allow residential uses. And so that's why I was going into that issue. And she continued to use adjacent and not adjoin. And therefore, we would submit that the city has failed to meet its burden of proof with respect to that issue with respect to 8.00.030 subdivision K2 with respect to the K-rail. But also, in any event, ultimately, the K-rails were removed, which I know the goal of code enforcement, which both officers have testified to, is to come up with a voluntary compliance. The K-rails were removed, and like the vegetation issue before, based upon Mr. Brutico's testimony, to the extent the hearing officer upholds the K-rail citations, we would request that the fines be reduced or eliminated, because ultimately the ownership did remove the K-rail. It took a little time, but it wasn't a significant time. I mean, I know the prior officer mentioned that code enforcement cases can go on for a long time, a year, 2 years. I'm assuming Robbie has had code enforcement. I'm probably ask her that she's had code enforcement matters go on for long periods of time. I don't think a 2-month time period, in light of the circumstances, in light of COVID, in light of the resources, in light of the fact that Mr. Brutico informed them that he had to look at this issue, especially with respect to a law that was just passed the day before the first communication went out, I think is mitigating in terms of reducing or eliminating the fines. And I would ask Robbie right now, have you had code enforcement cases that go on for a year or 2 years?
Sure, and I've actually issued citations upwards of $100,000 on one parcel. So much more than this scenario.
So. And then the final, I mean, ultimately, I would argue or assert that retroactively changing the rules on someone when they were in compliance or not, or were not in non-compliance with the regulations, violates their due process rights, as well as their vested right to continue with the use that was allowed. It was not disallowed by the city's code.
Okay. Okay, any more questions or information or comments regarding the K-rail locations and citations?
So if I could just make a few clarifications, I think that
okay, briefly, Robbie?
Briefly, 3 points. I think we're hinging on adjoin and adjacent. Go to the dictionary definition. They both mean next to. So clearly the K-rails were on parcels that were adjacent or adjoining residentially zoned property. You can see that by the aerial map of all of the parcels. And then there was prior communication regarding the violations with staff prior to community enrichment's involvement. That's all I have.
Okay, thank you.
And I would respond to that I'm not aware of any provision in the city's code which says you refer to dictionary definitions on how to interpret the language of code provisions. The city decided to use a specific word, so you have to assume they use that word purposely, and not to be, made synonym with other words later.
Okay, and so just to clarify, all of those cases have been cleared at this time?
All of the K-rail barriers were removed, yes.
Okay. Okay, so leaving our last citation, 20-2055, regarding the clubhouse. Robbie, you would like to briefly summarize the history?
Yeah, again, I'd like to go into all the, the gory details with every specific date. I'm happy to do that, but it's all outlined on the appeal hearing summary of action, which I have a copy of. The most up-to-date appeal summary is on the third document, which is 69 pages, which I believe was emailed last week. I think it was Monday, if I'm not mistaken, to the appellant and Mr. Krolikowski. You have a copy there. The pertinent municipal code section for this is municipal code 8.00.030 unlawful activities, section G. There were a total of 15 citations that were issued on this case. This is specifically with regard to the former clubhouse. Those 15 citations totaled $6,800. This case began the 15th. We had a concern reported regarding the boarded up former Deer Ridge golf course clubhouse. I began with a phone call to the property manager, left him a voicemail. We had the email exchange. Mr. Blake indicated he did send a letter specifying that he had some concerns regarding the ordinance. I did respond back to him and let him know that I did have to proceed with the enforcement action. The inspection was conducted on August the 18th of 2020. The clubhouse was, which was in violation of that municipal code section. The municipal code section specifies that if the building is going to be secured, it can be secured with a clear or semi-clear polycarbonate material, which it was not. It was, they utilized wood for that. And there's also a requirement for signage to be posted on the building, which provides contact information for the property owner or property manager. That was not in place. So we issued, I issued the 72-hour notice, mailed it, posted it on the property, emailed it, etc. And then went through a series of weekly citations, which commenced with the first citation on August 23rd, ending with the 15th citation, which was the last or most recent citation, having been issued on December the 15th. I will tell you that we did have some progress towards compliance. Let me go back and give you that date. On October the 2nd, October 2nd, 2020, I conducted an inspection. And at that time, although the clubhouse building was boarded up, there was some signage that was posted on the front of the building. However, my vantage point, which was at the entrance off of Foothill Drive, I couldn't read specifically what the signage stated. The citation was issued on that day because whether or not the signage was posted, house building, former clubhouse building being boarded up in violation of the ordinance. And then I did receive clarification from Mr. Brudekow specifically on October the 13th. He emailed me to indicate that the appropriate signage was in fact posted on the property and provided me a photo of the sign with the language. Again, I wasn't able to verify it in person because I would have had to trespass onto their property to walk up to the front of the clubhouse to view the sign itself. But from the photo he provided to me, it did meet the municipal code requirement for the signage on it. And I think I will stop there so that we're not buried in all the specific details. However, if you have any regarding the process or any specific citation, I'm happy to go back and the citations along with photos of the violations are included along with a printout of the relevant municipal code section.
And you said the last citation was issued on December 15th or 18th?
December 5th.
Okay, thank you. All right, Mr.
Okay.
Krakowski, would
Yes,
you
yes.
have
So-
questions?
so You went out there one time and you did see a sign and you weren't able to see it, but then you still issued a citation after that?
As I indicated, there were initially two specific violations. One was in regards to the building being boarded up with wood, and then secondarily was the signage. So whether or not one of those two issues was resolved, there was still a violation on the property. Therefore, the citation was still issued.
The citation was still issued for the signage, even though there was signage on there?
The citation was still issued for the violation of that code section, which is section G, the boarded up building.
Yeah, not my question. Was a citation still issued for the signage, even though you saw that a sign had been put up?
The citation was still issued on October the 2nd because I could not specifically read the language that was on there. It wasn't, and then there was another citation on October the 9th, which was the 7th citation. It wasn't until Mr. Brudica provided a photograph of the sign on October the 13th that I was able to confirm that that signage would meet the municipal code requirement.
So you could see signage from a distance, didn't go on the property to check it out to see if it was compliant, and still issued a citation for signage?
Issued a citation for a violation of section G, which was a failure to maintain the vacant building or site.
Which included the signage.
Part of that, yes, sir.
Okay. Okay. So when you don't see something, you still issue a citation for it? Is that how you do things sometimes?
No, my testimony is that the building was boarded up, which was a violation of that section E, so a citation was issued.
Okay, but that included the signage though, right?
This is under item number 5. The temporary covering over the doors and windows is under 3.
Okay, so you still did it. Okay. When was the boarding put up on the building?
Perhaps Mr. Brudicow can give testimony on that. I monitor that property on a daily basis, so I wouldn't be able to give testimony to that.
Well, was it before COVID or after COVID shutdown?
Is it included on that email that you have? I don't know.
Maybe you're the code enforcement officer. You're supposed to have the file on this. Why don't you have the file, the emails from Mr. McCann in your code enforcement file?
There wasn't a code enforcement action. Those are not part of my file. I don't have other people's email communication in my file, sir. My file contains my actions, and it would be the emails that I have correspondence with any related parties on the property. For example, Mr. Brudicow.
When did the rule change that you couldn't cover up your buildings with boards and paint them the same color? When did that rule change?
That municipal code modification would have been the same dates that we previously discussed with regards to the K-rail barriers. So that would be the first agendized meeting was June 23rd of 2020. The first reading by Mr. McCann, staff report, and then the second meeting was July 14th. The ordinance would have went into effect 30 days thereafter, which would have been August the 13th, 2020. There has always been a requirement to secure a building, but specifically with regard to the boarding up, that was modified on those dates that I gave you.
Okay. Now, boarding up of buildings was identified as the appropriate thing to do before August 13th, 2020, correct?
If that's something that's in that email, again, I don't have a copy of that email, sir. I don't know what the content of that email is.
Well, no, before August 13th, 2020, didn't the code allow people to board up a building and paint the boards the color of the building?
We never had a requirement to paint the boards, sir.
Oh, okay. So you're saying that before August 2020, the city did not have a municipal code section which says if you have a vacant building, you're supposed to put it up and paint either the boards the color of the building.
Our municipal code stated that you needed to secure a vacant building. There was no language that specified that you needed to paint the boards a particular color now.
Now, did the city ever told Mr. Brudico to board up and paint the building?
I believe there was communication between other city staff. I would guess it was probably Mr. McCann and certainly Mr. Grindal with Mr. Brudicow. I'm not privy to the specific details of those conversations because I wasn't part of that call. And again, I don't have a copy of that email that you put on the screen here from Mr. McCann. But the information that I was provided by Mr. Grindal was that Mr. Brudicow and the golf course was provided prior notice that they needed to secure the building, remove the K-rail barriers, etc. But that was all a verbal conversation with Mr. Grindal.
Was Mr. Brudico ever notified before August 13th, 2020, that the city wanted him to board up the building and paint the boards the color of the building?
I never provided him that. If another city staff member did that, I'm not aware of that.
And so do you think it's appropriate to have the city tell someone to do one thing and then change the rules and then require them to do something else?
My opinion isn't really at play here. It's the municipal code. I enforce the municipal code as written, sir.
Okay, well, let's take a look at wrong one. Trying to find the email here. Shoot. Wrong one. Okay. Do you have the document here? My name at the top? Do you see that? Okay.
Anything else?
So this is an email in March 12, 2020, which is before the COVID shutdown, correct?
Yes, sir.
And this is the email from the Director of Community Development. And on item 1.1, the bullet point on second page says, Deer Ridge Clubhouse, paint the plywood door and window coverings to match or be highly compatible with the exterior wall color. You see that?
Yeah.
So in March of 2020, the Director of Community Development was telling Mr. Brudico that the wall coverings and the door coverings he needed to paint to match the exterior wall color. You see that?
Yes, I do.
Okay. So now you have the city, an official, a supervising official at the city, telling Mr. Brudico for the wall coverings and door coverings, he should paint them, right? Correct?
That's what the screen shows. Yes, sir.
Okay, and now you're saying that's illegal based upon the code that was adopted in August of 2020?
I'm not saying it was illegal. You asked me if I was aware of that, and I told you I was aware of that communication. I don't doubt that communication took place, but was I aware of it? No, I was not. I also made it clear the municipal code did not require the requested from what you screen or so, but the municipal code did not require that.
Okay. And you're sure about that? Prior to August of 2020, the municipal code did not require that vacant buildings that be boarded and painted the same color. You're certain about that?
Secured, but I'm not aware of any municipal code that specifically states that.
Okay. So now you're issuing citations to Mr. Brudico for boards over windows and coverings that are painted the color because he's not allowed to do that now?
I was enforcing the, sir.
Okay, so you're issuing citations to the property ownership for boarding up the building, correct? And not using the polycarbonate?
The options were to secure, excuse me, let me back up. The requirement was to secure the vacant building. If the secured without the plexiglass or the polycarbonate sheeting, that's certainly acceptable. And there's been several during this whole enforcement process to let Mr. Brudico know that he could remove the boards as long as the vacant building remains secured. He doesn't have to put the polycarbonate up, but if he wants to provide some material to secure the openings, the doors and windows, it would have to be the clear or semi-clear polycarbonate material as specified in the municipal code.
Okay, he can't board it up and paint it like Mr. McCann tells him he should.
That's not what our current municipal code specifies now.
Okay. Okay. So, and by the way, how much did it cost Mr. Brudico to board it up and paint it based upon Mr. McCann's request?
You would have to ask Mr. Brudico. I haven't had a conversation. No idea.
Now you said twice today that it was a former clubhouse building. Why do you say it's a former clubhouse building?
Open, so that's why I would call it a former clubhouse building. It's not a current clubhouse. It's not open for business.
It's not open for occupancy right now, correct?
It's not open for business.
Okay. And so when did it stop operating?
I don't have that off the top of my head, sir, but I would say that it's probably been at least a year and a half to 2 years would be my best recollection. It's been quite some time.
Okay. And do you know whether the use of the building is an ancillary use to the golf course?
It is a permitted building on a separate parcel. The former golf course, I should say, was not part of that parcel. The golf course was on the adjacent parcels. That particular parcel was the former clubhouse building, pro shop, snack bar, what have you.
Do you often issue citations for properties when you don't actually see the violation?
No, we would have to view the violation, and in this particular case, I did view the violation.
Well, no. I mean, with respect to the signage, you said you saw the signage from a distance, didn't check to confirm whether it was appropriate, and still included that item on the citation. Item G.
I'm going to interject. I'm going to interject here because she's answered this question multiple times.
Okay.
And that item, that violation 8.00.030 unlawful activities G includes both signage
Oh,
and boarding.
yeah, I understand.
So when it was issued for G, it included the boarding. So, and there weren't separate citations each for the boarding or the signage. There was a violation of section G, and only one citation was issued, even though there were two areas that at times were not within compliance. So I think we've got that, and let's move on.
Okay, I understand. The hearing officer wants to make the point about the case. Okay, so now the golf course, when it stopped operating, isn't it true that the accessory use of the former clubhouse that you referred it to also stopped operating?
There was no business at that site. Again, I'm not really sure what point you're trying to get at. The municipal code section, the violation is for a vacant building or site, and it was in fact a vacant building or site.
Okay. Now, did someone direct you to start issuing citations with respect to the boarding up of the clubhouse?
A verbal conversation with the interim director, Mr. Jindal, as regards to the K-rail barriers along with the former clubhouse building.
Okay. And what did he tell you about issuing citations related to the boarded up building?
The conversation was that the municipal code was in effect. There were violations on the property, and that I needed to follow up on those violations with enforcement action.
He didn't tell you that the uses had already been grandfathered in because they existed before the city decided to change its laws?
I just gave you my testimony. That is the extent of our conversation, sir.
Okay, so the answer to that is no, he didn't tell you that. Did you ask him that? Did you ask him, hey, these seem like new laws. What were the laws in place, or did the property owner comply before the city decided to change the laws?
I've answered your questions, sir.
Did you ask him if the uses had been grandfathered in any way?
I gave you the extent of our conversation, sir. That was the extent of our conversation. I received direction from my interim director to address the code violations at the property, which I did.
Now, does 8.00.030 subdivision G3 allow for the use of boarding materials and painting to cover up a vacant building?
You'll have to ask that question again. You were cutting out, sir. I didn't
Oh,
hear
I'm
you.
sorry. Well, does the code allow 8.00.030 subdivision G3? Does it allow to use boarded materials painted with a color consistent with the exterior's primary background for vacant buildings?
For vacant buildings in all other zones. However, this building is adjacent or adjoining, however you wish to term it. If we want to go specifically with the municipal code, which would be best, under subsection A, it talks about consisting of the minimum 0.177-inch thick clear or semi-clear shatterproof polycarbonate sheet or adjoining a property zone to allow residential development, which it does in fact adjoin residential development. You can see from the aerial images that there are adjoining properties which are residential.
Okay, so the actual, and what parcel is the building on that you've issued these citations for?
The parcel the building is on is APN 007100131 on Foothill Drive.
Okay, and that property directly adjoins a property zoned to allow residential development.
Correct.
Okay, and what's the zoning of that next door, that adjoining residential development?
Well, let me pull up the map to answer your question there. Those are, it's a planned development. Those properties on Augusta Drive. Those homes are adjoining the parking lot area of the former clubhouse building. It'll take me just a moment and I can give you that. So those adjacent or adjoining homes are PD 20. That's planned development 20. Those are residentially zoned properties.
And those adjoin the clubhouse?
Correct.
Other than the interim community development director, did anyone else ask you to initiate code enforcement proceedings against the subject properties?
Did anyone else ask me to what? I didn't catch the last part of what you said.
To initiate code enforcement proceedings against the subject properties?
No, nobody asked me to introduce code enforcement proceedings. Did we receive reported concerns from the general public? Yes, we did receive reported concerns from the general public.
Okay. I have no further questions. Roberto, before I ask you questions, do you have any specific things you want to bring up before I ask you questions?
No, I think
Okay.
I think code enforcement was put in a difficult position because of the political nature of this of these law changes in response to a closed down business.
Okay. So, can I ask my client some questions?
Please go ahead.
Oh, okay. Mr. Burdico, when did the golf course and clubhouse stop operating?
We've been in early September 2019.
So, well over a year ago, correct?
Correct.
Okay. And did the clubhouse and golf course have any type of land use approval that made them connected to each other or interlineated with each other?
Well, the clubhouse operations were, as my understanding, were a use that was ancillary to the permitted use of the golf course. That's true.
Okay. And the golf course shut down, correct?
Correct.
So the clubhouse approval for occupancy also shut down, correct?
What it was, our understanding, it was not approved for occupancy if there was no operating clubhouse. That's correct.
Got it. Got it.
I mean,
no
operating golf course. I misspoke. No operating golf course.
And that's been for well over a year now, correct?
Since early September 2019, yes.
Okay. And did anyone ever tell you, now you're aware that in August of 2020, the city decided to change the rules to require this polycarbonate covering for vacant buildings?
Yes.
Okay. Prior to that, did anyone at the city express to you or request that you do something to secure the building?
I do not know if that request was initiated by the city. We were under the impression, I don't know if I got this impression from somebody at the city, that once we closed, we needed to take steps to secure the building, and we did that. I can't remember if they initiated it or we just did it.
Okay.
So,
And did Mr. McCann ever communicate to you regarding the efforts you made to secure the building by covering the windows and doors with wood?
he did. We had a number of conversations, and ultimately he put a letter out to me with one of his requests in it.
Okay. And that was the email we've been referring to
It is,
today?
yes.
And he
Yes.
asked you, with respect to the coverings that you had put on the building, that he wanted you to paint them a similar color to the exterior, correct?
He did. That was, again, it was after conversations about how the residents in the adjoining area were annoyed. They didn't like looking at bare plywood. Would we be willing to paint it? He understood that we had to put the plywood up to secure it, and he asked if we would paint it. And so what you're seeing in that email, which I don't have in front of me, but I sent to you and I vaguely remember, he's just, it's confirming a conversation. We say, can you get this painted?
Mm-hmm. Okay. All right. And did you incur any expense in covering up the property and painting it as requested by the city?
Yeah, well, we did it in two steps. We first covered it up with plywood to secure the property and prevent, there's an awful lot of vandalism that's occurred and things that go on inside vacant buildings and that vacant building. So we had to take steps to address that. And even I think under the city code, they want you to do that. So we first boarded the windows and blocked the doors and that sort of thing. When the issue of the residents being annoyed because it was bare plywood came up, we went back and had somebody paint that.
And I would assume you incurred expense in having to do that work?
Yeah, each step, yes, of course.
Okay. And has the city offered to reimburse you for doing any of that work? Because now they've changed the rule. Now they've tried to change the rules on you?
No.
Okay. Has the city offered to, hey, you know what? I know we changed the rules on you and we told you to do something. We changed the rules. Maybe we'll pay to put the polycarbonate. Offered that at all?
No.
Okay.
But I've
Similar
offered to do whatever they want. If they want to foot the bill, I've offered many times to do a number of things along those lines with all these code enforcement issues.
Okay.
In fact, I'm sorry, it just occurred to me, Charles, hold your question if you don't mind. It came up earlier, but I think it's important for the hearing officer to even hear. Relative to the K-rails, one of the very first responses we had when we were discussing at the upper levels of the city management was, we explained our liability concerns. We said, but if it's really important to you, how about we'll follow your direction, but just indemnify the golf course if there's a problem, if somebody gets hurt, if somebody's complaining about the notice wasn't adequate or the visibility wasn't right or whatever. Almost all of our responses to the city were open kimono. Hey, this is what's happened. This is why it's happened. And we can cooperate within the ability of the Deer Ridge Golf Course to do that. And this was no different here with painting and why we'd be happy to take them down if there was a grant or they provided the money to put up the this new polycarbonate type of shielding, which I think is only required in certain parts of the city, not all across the city as I read the code. Again, very targeted to us.
And again, you brought up this issue of safety. Do you think the boarding up and the painting is your attempt to make sure the property is safe, not only for you but for people trying to trespass or get into the building?
Well, yes, there's a number of levels of concern here, and I know the city must know this. Certainly the police department knows it. I suspect that Robbie and and I suspect the engineering officer knows this, but there's probably 3 levels of concern. The concern is somebody breaks in and there's illicit activity of one nature or another. You could have homeless moving in, and when they move in, sometimes, and we haven't had this at this particular property, but other properties we definitely have, homeless move in, the utilities aren't right, the heat's not on, they start a fire to keep warm, and next thing you know, you got a fire. We've had situations where people are dealing drugs inside of buildings that are closed down. We've had situations where there have been other types of illicit activity going on. So you got to shut it down to protect the public. And then we've had some break-ins where people get injured. So somebody breaks into this place, nobody sees them, they break a leg, they trip on something, there's an exposed piece of metal, they get cut, they get injured, they bleed, who knows what happens. So we want to board it up and secure it as best we can to protect the public. But, quite honestly, it's also so we do what we need to do from a liability perspective. So the owner can say, look, we took steps to prevent this from happening. You can never prevent everything from happening, but our understanding is under the law, you've got to take reasonable steps to try to prevent. So that's an issue. And then the third issue is the insurance company. Insurance sometimes will not cover you if you are negligent, or if you are grossly negligent, or if you should have done something. Sometimes they'll try to escape coverage. So you've got this 3-legged stool that we're trying to address and take reasonable measures, which were, I think, not just permitted, but probably required under their code prior to the change, to secure the building and secure the property.
Okay. And did the director of community development, after he told you to paint the door coverings and window coverings, did him or the next interim director say, hey, guess what? We're going to change the rules on you. We're going to make you do something different now. Did they ever tell you they were going to do that?
They never contacted us to say they were going to do it. We did get some word that the council was upset because residents in the area were upset and they wanted to make changes.
Mm-hmm. Got it.
I could not tell you where that came from, but we were aware at some point that they were considering this ordinance right about the time they were adopting it.
All right. Any other comments or thoughts about the boarding up and painting of the windows and doors?
Well, that's yet another different issue because you've got, and I know you're going to make the legal arguments in a bit about whether that ordinance applies on its face, but this is a different issue too because here again we had to get legal counsel. We proceeded as quickly as we could given the constraints, and I'm thinking if you're taking reasonable measures to promptly correct something, you should be at least not punished for that. But it does take time, and everybody on this call should realize it takes time to find. There are peculiarities here. I think we all should admit that. It takes time to figure them out. It takes time to get an attorney. As I said, we tried to engage a couple of them in Northern California that had some experience with Contra Costa County. That didn't work out for reasons. It took a while, and if you ever try to engage counsel, sometimes you'll understand the process. And with COVID, it wasn't easy. You have to track them down. They're not in their office. And they get back to you, and then they got to run a conflicts check and all this stuff. And then you got to tell them what's going on, and they got to decide if they can be helpful. So these things take time. Eventually, we got to your firm, Charles, and you folks were able to assist us with analyzing the issues. In the case of these polycarbonate windows, so in addition to the time it took just to get with you, we have a completely different issue now here with the retroactive rule change after we're told by a city official, board it up, and by the way, paint it, and everything should be good. And on top of that, as I've said earlier, Deer Ridge Golf Course has no money. So we've got an impossibility situation here. If you take everything down, take the plywood down, now you've got a liability issue because people can get injured, can have problems. Graffiti inside, outside, I mean, that's what will happen. We just got a code enforcement notice, I want to say last week, for a graffiti issue on a restroom on that golf course. Now, we got to go out and paint it and find somebody to paint over it, and we'll do that. I think it's maybe already done as of today. But these are the things that happen, and you just got to use your best judgment. And I know these rules were put in place by the city to deal with the public being annoyed that this poor business couldn't sustain itself and went out of business. And now, instead of trying to support the business that operated there and the millions of dollars that were lost there, there's this punish the bankrupt mentality. And this is what we got to deal with in this call and in this hearing. There's got to be some fairness applied. We know the community's upset. We know that a lot of them feel badly. They bought a house on a golf course and the golf course isn't there. But darn it, that's not the fault for this ownership group trying for 10 years, maybe closer to 15, and losing, many, many millions of dollars trying to make this work. At the end of the day, it couldn't. In 3 or 4 years before it went out of business, it told the city that and tried to look for solutions. We thought we had one, and that was blocked. I want to say mid-2018. That was blocked right before the Planning Commission. It was something that took 18 months to develop and another $1.5 million to get done. But that would have involved rehabilitating both golf courses by providing a limited amount of space on either side for senior housing, and the money from senior housing would have paid for the changes needed, and then would have provided some funds to provide for ongoing sustainability. All right, community rejected that planning, so it never got to the Planning Commission, was pulled a week before. Finally, in the face of all of this, the business succumbs, and now the community is completely annoyed because it closed.
Yeah.
And that's what's going on here. And now it forces these rule changes retroactively, and now we have this ever super vigilant code enforcement. I'm not saying anything against Linda or Robbie. They just did their job, but it's not fair and it's not right. What we should be doing is try to figure out how to help that business and help that property recover and get repositioned. We've been working on that with a not-for-profit group now, and we hope to have some solutions. But this is no way to treat a business and something that's important in the community. And I'm sorry if I'm going on and on, but this is just such a peculiar situation. The city of Brentwood would react like this instead of trying to find solutions.
And with respect to after taking the time to review what they had decided you for, the signage, you put up the signage, right, that they were complaining about?
Right. I didn't even notice that at first because it was, there was a number of items, mostly just K-rail violations.
Mm-hmm. Yeah.
And I didn't even really notice the signage issue. I think maybe Robbie pointed it out in one of her emails, or maybe I just came across it. I don't remember how we finally figured it out. The signage was a relatively easy thing to address. Quite honestly, the harder thing was to get the phone number. So we had to get a phone number issued because the other phone number was gone at that point. But
okay.
The signage went up, and we were able to do that, and that was something that we didn't have an issue with. It didn't create prospective liability on the property owner. These other things, there are different issues involved.
Yeah, but what I'm getting at with respect to the signage, the K-rail, and the vegetation, you ultimately complied with what the C was requesting, correct? Right?
Yes, we went.
Okay.
We went down a reasonable path.
With respect to this boarding up of the windows, you're disputing that because you were told to do it that way. You did it that way. They changed the rules. And also based upon an argument I'm going to make later, you may think it does not apply. Are those some of the reasons?
And there's no funds available to do it, to put the polycarbonate up.
Yeah. Okay. All right. Thank you, Roberto. Anything else, Ms. Gailey, other than I've got a short legal argument to make?
Sorry, I'm taking notes on the last points that he was just making on specifically
sure.
What he was mentioning to support disputing the violations. You'll give me 1 second to complete my thought here. Okay, thank you. I don't have any further questions or comments unless you want to summarize or add any additional information?
Sure. I don't know if Robbie wants to go first or I could just go, whatever. Robbie?
Do you even have anything additional that you need to add? Okay,
Okay.
then go ahead, sir.
So,
I'm
as
good.
Mr. Brudico testified, because the property has been shut down for more than a year and because it was an ancillary use, it's no longer occupied or approved for occupancy. The statute
Did we lose you, Mr. Kolakowski?
I can't hear anything. I think it's just buffering.
Well, you still got Roberto Brudico on the call, and I can't hear him either.
Yeah, I can't hear or see anything there.
Yeah, it says he's still connected, but
It says
Let me send him
due.
I'm going to send him a text message and see if he can if he can do anything about this. But great
Okay, well,
time for it to fail.
there's a note on here. It says due to low bandwidth or local computer conditions, such as CPU or RAM use, video is not currently available. Will resume automatically when conditions improve. Could you text him and ask him just to dial in?
I'll be happy to do that. Hang on.
That'd be great. That way we can summarize.
All right, I texted him. The trick's going to be whether or not he's got his phone at the ready. I hope he does.
Well, maybe miraculously the bandwidth will get better.
Hello?
Hi, Mr. Kolakowski, you back with us?
Yes, yes.
Okay, great. We lost you. There's a note here that says due to low bandwidth or local computer conditions, such as CPU or RAM use, video is not currently available. So we lost you.
Okay, all right. Yeah, I just, yeah, I was, yeah, my screen went blank, and I think, so I'm calling in.
Okay,
So,
great. We can hear
Are
you.
you, okay, you can hear me, great, okay.
Yes.
So, as testified by Mr. Brudico and unrefuted by the city, Section 8.00.030, subdivision G, with respect to vacant buildings or sites, specifically says, no owner of a building approved for occupancy shall fail to maintain a vacant building or site. Okay. Because the property is no longer approved for occupancy, this provision does not apply any longer. The building is not being occupied, it has not been occupied, and because it was an ancillary use to the golf course, which golf course use has now ceased, it is no longer allowed for occupancy. Therefore, this section does not apply to this provision. In addition to that, as the evidence has been presented, the requirement to board up, which was a requirement, the ownership did. The city requested them to do that and paint them to match the color, and they did that at the city's request. Then after they did that, the city then decided to change the rules. So again, we have another situation similar to the K-Rail situation where the alleged offending use had existed prior to the change in the law. And therefore, again, we also have a vested right / legal nonconforming / grandfathered use in place prior to the city changing the rules. In addition to that, again, like we've talked about before, the issue of what adjoining residential use can be vague and ambiguous. as well as the fact that, again, like Mr. Bruto has testified, it has taken him some time to evaluate these issues. He did so. He resolved most of the issues except for this boarding issue, which he disputes based upon some of the legal and factual grounds we presented today. This is not something that's being done in bad faith. He's trying to work with the city, and I think there's evidence of that by him complying with them, even though they changed the rules on him. And so with respect to this particular issue, we request that the hearing officer determine that the section 8.00.030 subdivision G does not apply to the property, and or that he already had a legal nonconforming or vested right to continue with the use. In the event the hearing officer decides otherwise, we would also request that any fines affiliated with this issue with respect to the boarding up of the building be reduced or eliminated, as this has been, from the ownership's perspective, a rough time for them. They had these things in place before COVID even hit. As soon as the rules changed, the city was on them about the change in the rules, and they took a little time to evaluate those rules and to resolve most every one of the issues. So it's not like we're sticking our head in the sand, or the ownership sticking their head in the sand and not looking at these things and not trying to work things out. So with those comments, Mr. Brutico, do you have anything else you want to add
No,
to that?
I think you've summarized it reasonably well. We've been through a couple hours now, 3 hours, looks like, of phone conversation. But with every appeal that was submitted to, I've never had this particular situation arise on a property we were engaged in managing on. My understanding is the field people like Robbie and Linda are out there just trying to do their job, and we're having conversations with people like Terrence or people like Casey, and they know what's going on, and we're making offers of cooperation. But I would also add that in every single letter to Meg Wimberly, we indicated we are going down the path reasonably, and we're trying to engage counsel. We have engaged counsel. We've got to get advice, and you can see there's these conflicting pressures on the ownership here. One is newly changed laws. Do they apply? Do they not apply? We know the city wants them to apply, but do they apply? And what's the consequence of taking action? Is the bigger consequence the liability because somebody's injured? Did you do enough to show you weren't negligent? Those are all questions that are legitimate and need to be asked and need to be answered by counsel before precipitous action can be taken. So I would just have you keep that in mind.
Thank you. Anything else from the city?
So I have just one point of clarification with regard to the way Section G is written. When the code language specifies no owner for occupancy, that has nothing to do with land use or zoning. That has to do with a certificate of occupancy issued by the building official. So I just wanted to make that clarification. The building was approved for occupancy when all of the initial final building inspections were passed, and the building official issued a certificate of occupancy. So the reason specifically, just to give you a little bit of clarification, why the code section is written that way is that we certainly wouldn't want to enforce this section on a building that's under construction, for example. That building that's under construction and has not yet been completed has not been approved for occupancy. So the section would not be enforced on a building under. So just wanted to make that point of clarification. It has nothing to do with land use, ancillary uses, zoning of a property. It's specifically with regard to certificate of occupancy by the building official.
Okay, was that Robbie speaking?
Yes.
Okay, well, I would disagree with that assessment. I don't think a code enforcement officer, I don't think you have the right or the ability to interpret code sections. It doesn't say certificate of occupancy, it says approved for occupancy. If the city wanted to include specific language to meet your interpretation of the code, then they could have done that. I take issue with you trying to make a legal determination as to what a provision means or doesn't mean. And the fact that we have testimony that these were ancillary uses and that the occupancy, the use and occupancy of the property ceases when the use of the golf course ceases, that is unrefuted. I asked you about the CUP earlier. You had no knowledge about that. I asked you about ancillary uses and you had no knowledge about that. So I don't think your interpretation of the code meets any legal requirement or legal analysis that can be used when the language doesn't say what you want it to say.
I'm going to go one step further, too, and it's not meant to be respectful. I think that Robbie is looking only at the front end of that law, meaning they wouldn't apply it when you're under construction, but I don't think by any means that suggests that they would not when it was their interest to do so if you were no longer approved for occupancy. And I'm going to give you a specific example that came up relative to Deer Ridge. When we were talking about potential reuses of the property, one of the issues was can Deer Ridge reuse the clubhouse for something like a restaurant or a community garden or some sort of a farm-to-table type of event center restaurant? And the answer we got back in our discussions, I believe it was with Casey at the time, was absolutely not, because the clubhouse only exists as a use ancillary to the golf course. When the golf course is closed, you're no longer approved for occupancy and use. Now, I don't know that I have a letter to that effect, but clearly there were discussions at that level, and clearly they make sense when you have something that's permitted as an ancillary use. When the primary use goes away, the ancillary use does not exist. It's no longer legal. So it's one of these situations. I hear what Robbie's saying, but it's sort of like you can't have it both ways. And if they wanted to be particular about certificate of occupancy, it'd be very easy language. Do I think they maybe wanted this to apply to us? Of course I do. It was raised as a political response to the business closing, but it's not an artfully drowned statute. There's a number of places where it's ambiguous. This is one of those ones where it just doesn't fit, and it's not fair to apply a statute that doesn't fit. And there are some issues of fairness and due process that have to be taken into account.
Okay. That
Anything else?
being said, do we have any other further thoughts or closing information that would like to be added?
This is Chuck. I think I'm done on my end. Roberto, anything else?
No, I'm done. I just think it's important to keep in mind the circumstances of how this came into place, how we have an ordinance that's put in place that then seeks to apply measures retroactively to situations that were already existing, and to just recognize there's an element of fairness and due process involved here that needs to be respected. If we're going to respect government, we're going to respect processes. That's it.
And Roberto, the K-rails and the boarding up and the painting, that all existed before the city changed its statutes in August of 2020, correct?
It did, and it really came up as a consequence of a liability assessment done by risk management. Once the insurance folks, or once risk management was trying to put the insurance policy in place and keep it in force, the issue of a closed business came up. Well, what steps have you taken to secure the property, to prevent people from breaking in and causing damage, or fires, or things that the insurance company has to respond to? What have you done to try to dissuade the public from entering on a property and injuring themselves? So all this came up shortly after, not on early September, because I remember it took a month or so before the issue was even raised. But once it got raised, then these steps were taken. I believe everything was in place by the end of 2019, well in advance of this. In fact, because we put them in place, that's what got the ire of the local residents. The local residents didn't like the orange K-rails. It bothered them. They thought there was some vindictive measure going on. This is what was told to us by the city. They think that we're messing with them because of the color orange or because of K-rail, and that this is somehow a public area to stroll through, and we're trying to deny them that after we've closed the golf course. Nothing could be further from the truth. So all this was in place, and it's what sparked the councilwoman to put the changes forward, and the law got passed, and now we've had to deal with the aftermath.
All right. Thank you.
Okay.
All right.
So I think we've had ample time to review the violations, collect information, hear from both sides. I have taken copious notes, and I will be making and providing my written decision within 30 days. If you don't mind, could each of you email to me your preferred mailing address so that I can include it on the letter? It will be coming from the city clerk, but my email address is dgaley@brentwoodca.gov.
brentwoodca.gov. Okay.
Correct.
And should I also email you the exhibits I referred to today and copy the city clerk?
Send all of that in one email. Send it directly to the city clerk, please, and copying me.
Okay. City
Because
clerk
she
and
will be
copy.
the official keeper of all communication.
Got it. Okay. Very good.
And just a final housekeeping item. One of the objections made at the start of the hearing is that the hearing should not proceed until we have a response to the Public Records Act and get the documentation. And so since we were denied having that to assist with putting on our case today, we still need to have that request completed. We still need to get the documents because we're not sure where this is going. I'd love to have comfort that this was going to go away and either the fines go away or these decisions reversed or whatever. But short of that, we're going to need those documents. And I think it's, again, to say what Charles said, we were disappointed not having the opportunity to have them such that we could have used them today in handling this appeal. So somehow in your decision, we need to make sure we're still on track to get the documents and that our objection about having to proceed today without them is preserved and noted.
Okay. Include that request again, please. Do you recall the date of that request?
Yes, the public records request was sent on, well, I'm going to send you the letter. December 17th, 2020. The city has 10 days under the Public Records Act to provide the documents, unless they ask for an extension, which they did not.
Okay.
So
you just want to include that in the email as well, that's fine.
I'll put that in the email. Okay, I'll include that in there. I mean, I think we've already made a record today, and that was noted by you earlier on. But I'll make sure to include that in the request, or with the documents to the city clerk and the information about our addresses.
Okay, sounds good. And Jennifer Schultz is representing the city clerk this morning. Jenny, you still there?
Yes, Deborah, I'm here.
Okay, great. So those will be coming to Margaret, which I'm sure you will see very soon. And I can include those addresses in my decision letter that I will forward to you to distribute within 30 days.
Thank you, Deborah.
Okay. Thank you all. With that, I think we are ready to conclude.
All right, thank you.
Thank you.
Thank you.
Bye.